Hey, welcome to our channel. Today, I'd like to discuss your criminal history, if you have one, and how that might affect your ability to apply for federal programs, including Section 8. And those of you that may have other issues related to your arrest record or criminal history in the past, and you're considering applying for Section 8, but are unsure as to whether or not it would be accepted or denied as an application. Before I get started, my name is Jay. I'm the owner of Section8Consulting.com. Worked about 26 years at the federal level helping clients navigate Section 8 and housing. And you can find some of our company information below, especially if you're struggling. Do keep in mind my office is by appointment only, and our services aren't free. I'm not funded by the U.S. government or any grants, so this is a private solution. But anyways, let's go ahead and bring in some notes for you guys. And I'm also going to put these notes in the comment section as well as the description. That way you can recap the information if you have some further concern. And one additional note, we're going to talk also about the effect of drug activity and drug use. But do keep in mind that I'm going to cover that contentiously in two separate videos, okay? All right, so the notes we've got up. Yes, criminal history can affect Section 8 housing and eligibility, but most criminal records do not automatically or permanently disqualify somebody, much to the disbelief of many. A felony conviction by itself is not a universal lifetime ban either, and the outcome depends specifically on the following factors: the type of offense, when the conduct occurred, whether the conduct is recent or ongoing, whether or not the Housing Authority's administrative plan bans this or allows some latitude, and whether or not there's been rehabilitation or other mitigating circumstances. And there can be a lot. Whether the person is with a record. Would live in an assisted household, and that also means not just yourself if you don't have a criminal record, but anybody that's currently in your home under that voucher or considering being under your voucher. Okay. Now you have to excuse my cat, office cat. He may occasionally pop through the video here. He tends to have his own mind. But moving on from here, federal mandatory restrictions. So a housing authority must deny admission when methamphetamine production is federally assisted in housing. There was a really strong push congressionally about this issue when methamphetamines were at their height, and so anything related to that is going to obviously create a bar from the system. Number two, SROs or sex offenders and registration. You can almost forget about that. They're not going to accept any SO into any form of housing. And then number three is going to be current illegal use, drug use. Now, again, I'm going to post a video later tomorrow afternoon. Let's see, that'll be for, I think, 8626, and it will be. I'm going to talk a great deal about the use of marijuana, whether legal, prescription, or otherwise. So if you want to catch that one and you have concerns regarding that specific matter, please don't ask me any questions in this video about it. Just wait till the video for tomorrow afternoon, and I'll also link it at the back of this video. Moving on from there, threatening alcohol abuse. Okay, so there are certain circumstances in which alcohol use becomes untenable and otherwise could bar or restrict you from continuing to utilize housing programs or to even participate. You can also look at these requirements that appear in Title 24, Code of Federal Regulation 982.553, and I will again connect up that linkage for that federal code. Moving on there, 3-year drug-related eviction restriction. So, a household generally must be denied for 3 years following an eviction from a federally assisted housing for drug-related criminal activity. Keep in mind that's two separate topics. There's drug-related activity, like the sale of drugs on a property while in use of federal housing or a voucher, and also a combination of criminal activity. It means that you committed some type of crime or have committed that crime on the property where you presently rent, and then you're up for a 3-year ban, which used to be 5, and in some cases a lifetime. However, the housing authority may admit that the household before the 3 years expire when certain circumstances apply. The responsible household member has completed or an approved supervised rehabilitation program, or circumstances no longer exist. For example, the responsible person has passed away, is imprisoned, or will no longer be part of the household. Thus, They're no longer under the HAP contract or federal rules for it. So moving on from their criminal history, and the housing authority may consider the PHA may deny admission when a household member is recently engaged in. Remember, whoever you're allowing to be in your home, your lease in any property, any given state, is any when you have somebody stay the night at your house greater than a week or 2 weeks, depending on the state, then they are a resident in that property. They have established some form of residency. And in accordance with that, if you've got guests over for your barbecue and they go out there and start shooting guns or injure, kill, or otherwise, then that plays all back into you, and you are absolutely responsible. You are liable, you're legally culpable for the activities of them, and you can receive the same demerits under the system under federal rules. So there's no single federal rule that automatically bans every person with a felony for 5 or 7 or 10 years, but the PHA establishes its own reasonable look back period and screening standards and under their administrative plan. Now, look, guys, we keep talking about administrative plans. Easiest way to discover how they're going to address both criminal activity and drug activity, specifically for that PHA in violations, is doing a Freedom of Information Act, better known as FOIA, sending a letter out to that PHA or Public Housing Authority and requesting their most current digital copy of their administrative plan. And the reason I bring up digital, meaning email, is you do not want them to print out a bunch of pages. You could run into a bill anywhere from a couple hundred to over $1,000 for the administrative time, costs, and as well as the actual physical copies of the prints. Okay, and moving on from there, you can also reference this under Title 24 982.54 and Title 24 982.552. Arrest or not convictions. Let's make a distinction, guys. When we talk about criminal history, there are those that have been arrested and thus then convicted. Convictions and arrests are not the same thing. Your arrest record shall not be counted in this respect, but there are special circumstances and exemptions to it. An arrest record alone is not a sufficient evidence that someone has committed a criminal activity. HUD states that PHAs cannot deny admission or terminate assistance solely based on or because somebody was arrested. However, the PHA or Public Housing Authority may consider reliable evidence concerning the underlying conduct, such as police reports, court records, witness statements, and admissions, even when the charge was dismissed or never resulted in a conviction. For voucher termination and federal standards of permit under the Public Housing and the act, it's based on a preponderance of evidence, and even with arrest or conviction, but have you reference what they call the eligibility and determination of denial assistance guidebook. Okay, it's a long one, all right, but it will spell out the federal procedures, how they're going to look at arrest, convictions, drug activity, and much more. And of course, I'm not going to go over mitigating circumstances, but I will include that in the notes below in the comment, as well as the description for those that want to continue to read on the notes that I'm going to be providing. Look, guys, I've enjoyed talking with you guys today. I just wanted to first bring this as a presentation to you, and then maybe we'll expand on this topic further as we digress in our next video tomorrow afternoon. We're going to cover the whole world of marijuana and the use under federal and state law and how that affects your Section 8. And there are serious consequences depending on where you are in the nation, and there are different views of how this will be interpreted under federal rules. I'm not going to talk in speculation, tips, or tricks. We're going to discuss actual federal law and state law, and that will be that will be the actual definitive result of which you can either trust or not trust. Okay. So that being said, I've enjoyed having you guys. We hope to see you this afternoon. We'll be doing another EDU or educational video. If you'd like to see our live videos and ask questions, then that will be on Tuesday, Thursdays, and Sundays at 11 a.m. Central Standard Time. Thank you and have a great week. Bye for now.